Good afternoon. This is Mitch Berry. Welcome to today's webinar hosted by Padgett Law Group. Again, I'm Mitch Berry, Arkansas Supervising Attorney with PLG, and I'm here with Josh Hopkins, the firm's Supervising Attorney of REO and Title Operations. Before I turn it over to Josh as he starts our discussion around today's topic, which is titling and detitling of manufactured and mobile homes in the states of Arkansas, Tennessee, Georgia, and Florida, I want to remind our participants that you can pose questions to myself and Josh at any time during today's presentation. Simply click the questions box in your GoToWebinar control panel and type your question. At the end of today's remarks, we will address your questions. As a reminder, this presentation is being recorded, and a copy of the recording, along with a PDF of today's presentation materials, will be distributed to all registered attendees in the coming days. Josh, my friend, thanks for joining me today, and I'll let you take it away.
Thanks, Mitch. Hello, everyone. We appreciate you joining us today and taking time out of your busy schedules to learn about this hot-button topic. My name is Josh Hopkins. I'm an attorney here at Padgett Law Group. I'm based in our firm's Atlanta office, and I oversee title and REO operations throughout the firm's practice states. Like I said, this is a very hot-button topic, one that we get a lot of requests for information on. And, it really affects us in the default real estate arena on a daily basis. My guess is most, if not all of you, deal with mobile homes in some capacity. I would like to first note that this webinar will focus primarily on manufactured mobile homes that were intended to be a part of the underlying real estate, so quote-unquote real estate transactions. We will not be discussing replevin here today, i.e. personal property loans where the sole collateral was just the mobile home. We're going to save that for a future webinar. Let me give you a brief outline of the topics we intend to cover today. We're going to talk about manufactured mobile homes in general, from the creation of those homes to when they're affixed to land, the titling of those, loan origination, and then we will look at the detitle process as it's available in the states of Arkansas, Tennessee, Georgia, and Florida. And at the conclusion, like Mitch said, there'll be a Q&A session. So let's go ahead and dive into the material. We'll talk about titling first. Basically, we're talking about prefabricated homes, manufactured mobile homes. We're not talking about modular homes. Modular homes are another form of prefab home where the pieces are taken out to the property. Those have different HUD numbers and VIN numbers, and those are not required to be titled like a vehicle. So we're talking about manufactured mobile homes that are subject to titling under the vehicle statutes in our states. When a home is fabricated, and these are homes that are, Clayton, Fleetwood, Horton, some of the manufacturers you might be familiar with, they're created and an MSO form is produced by the manufacturer. It's the manufacturer's statement of origin. Sometimes it's referred to as a manufacturer's certificate of origin, so MSO or MCO. And those forms, that's the first title to the home. And when somebody purchases the home, typically at a dealer on the side of the road, those forms are either then taken to the DMV by the dealer or by the first purchaser, and they're surrendered to the state's DMV office, and the state will actually issue certificates of title. These are the car titles, if you will. I mean, they literally are the same thing as a car title. And these titles are kind of what proved to be kind of the huge problem that we deal with on the post foreclosure side. But anyway, once the home is titled, typically as part of the purchase process from the dealer, they will factor into the sales price a transportation of the home out to a piece of real estate where the home is affixed. And when we talk about affixation, we're talking about literally physically attaching the mobile home or manufactured home to the dirt. And that's done by either some sort of a slab, concrete block and piers, tie downs, the tongue and axles are removed from the home. And this becomes, for all intents and purposes, a piece of real estate, just like as if the home was a stick-built home. If the loan is being originated through FHA, FHA will require a structural engineer letter. So an engineer will go out to the property at time of loan origination and confirm that it is on a permanent foundation, that the home is on a permanent foundation, and that the home can withstand winds up to X miles per hour. And that's an underwriting requirement of an FHA loan for that structural engineer letter to be in there. So now we've got this home. It's been titled with the state. It's been affixed. And now we're going to talk about different ways to perfect a lien. So now that you have this car title, you can literally perfect a lien on it, note a lien on it, just as if it was a car. This is one way of perfecting a lien. Another way is to actually have the borrower execute a security instrument. If we detitle the home, or if it's detitled at time of loan origination, then at that point it becomes real estate, and so then you would only need a security instrument. However, sometimes we see this hybrid situation, and you're going to hear about it a lot today. And basically, this hybrid situation is where the lender at origination will perfect a lien on the car title, and they will also have the borrower perfect a lien on the dirt via a security instrument such as a deed of trust, a mortgage, security deed, etc. So you might have this hybrid lien perfection. We see two different types of loans. When we get referrals for foreclosure referrals, we typically see two types of mobile home loans being originated. One is what we would refer to as a true mobile home loan. This is like a retail installment contract, but it's very clear immediately upon reviewing the referral documents that this was a mobile home. There's VIN number, identifying information for the mobile home shown on all the loan documents. There's no mistaking that this is a mobile home being the collateral for the loan. Often in the referral, we'll also get copies of the certificates of title, those car titles I keep referring to. Those will be included in the referral package. Those tend to be the quote unquote easy ones to deal with post foreclosure because the lender has a lien on the mobile home title, and typically, since we're talking about real estate transactions today, we're also being referred a security instrument to foreclose. And so we can do repossession. Typically, the states that we practice in will have a process through the DMV of a repossession process where the foreclosing lender can execute repossession documents that we will prepare, and we can get titles to the mobile home in the name of the foreclosing investor. So these type of originated loans are not the ones that really present the big problems. It's the second option that we see that really is the problem, and these are these true mortgage originated loans. This is a loan that's originated like any other stick-built home loan. Typically, there'll be a mobile home reference in the appraisal, but when the loan gets goes through underwriting, a lot of times what will happen is there will be closing instructions provided by the lender to the closing agent saying you got to sign all this, you got to do all this to make sure that we're perfected as to the mobile home. But unfortunately, a lot of times that just doesn't happen. The closing agent will sign the closing instructions. We see this a lot, but there was never a DMV search done. So if it looks like a house, it smells like a house, the closing agent attorney is going to treat it as such and not check the DMV records to see if it was titled like a car. And this particular situation is what's presented to us most of the time post foreclosure. And when those transactions happen, typically they just will record a security instrument. Sometimes they'll put a reference to the mobile home in there. There'll be a mobile home writer, and that's really the extent of what happens. Also, at closing, there will be title insurance that's issued. Typically, the endorsement that involves manufactured mobile homes is called an Alta 7 endorsement. There are variations of it, like a 7, 7.01, 7.02, but there's a laundry list of items that the closing agent is supposed to do to be able to issue that endorsement. But a lot of times what happens is the endorsement is just issued and none of the underwriting requirements to issue that endorsement are done. And so we get this post-foreclosure referral or foreclosure referral, and the client says, well, we have, title insurance. I'm sure they detitled the home or perfected a lien on the title, and a lot of times that is just not the case. But what the endorsement requires is it requires typically for the home to be detitled, or in certain circumstances, you can get away with an endorsement by making sure that the insured lender and the originating lender is perfecting a lien on the title. What that endorsement does, backing up a second, is it basically states that the manufactured mobile home is a part of the land. That's what the Alta 7 endorsement is. But a lot of times what happens is the title portion of affixing that home to the land, the deed title or the perfecting of the lien, does not occur. A couple other things to consider here before we get into the states, and that is GSEs and FHA and VA. There are underwriting requirements as far as calling for these to be deed titled, for the homes to be deed titled. And again, a lot of times this is not happening, which is frustrating for our clients when we get referrals and we have to request fee approval, typically post foreclosure, to do the curative. It's frustrating because some of these requirements called for the mobile home to be addressed at origination, and it was not. There are certain circumstances where it is permissible to keep that hybrid situation, where the mobile home will remain titled as personal property under a card title, and then there will be a security instrument for the land, and then post foreclosure, the mobile home can be sold at REO via both a card title as to the home and a deed as to the land. So we just want to point out that there are GSE ramifications for these. And then lastly, what happens when the home is not properly addressed at origination, when the originating lender's lien is not perfected? There's curative needed, and again, most of the time it's post foreclosure. We always attempt to do it non-judicially first. It's the quickest and most cost efficient to our clients to try to cure the mobile home issues post foreclosure non-judicially. But there are certain circumstances where we just are unable to do so, and then we have to file some sort of a quiet title action. So we're trying to push these things through, obviously, and get them to REO, but a lot of times they get put on a sometimes a long hold to deal with the manufactured home curative. So now I'm going to turn it back over to Mitch, and he is going to tell us how these things work in the state of Arkansas. Mitch?
Thanks, Josh, very much. Good summary there. So in Arkansas, this issue kind of came to a head in about 2003 or 2004, and it was an issue all around the country at that point. And we ended up with a case in bankruptcy court in Arkansas called Renault. It was a Renault versus Simmons Bank. And Simmons Bank had a promissory note and a mortgage that described the real estate on which the mobile home sat, and also described the mobile home. So just like everyone else at that time and everyone else on this call, Simmons was used to dealing with promissory notes and mortgages or deeds of trust. They weren't used to dealing with certificates of title like car titles when it came to what they considered to be a real estate loan. They figured that if the mobile home was attached or affixed to the land, the mortgage would be sufficient to perfect their security interest in the home. I want to stop there and kind of go back to the basics for a second, because Josh and I use the term perfection or perfect a lot. And just to remind everyone what that is, it's a legal term of art. It's the manner when you can have a lien, but you also have to perfect the lien. And by perfecting it, you establish your lien position against the rest of the world. So it puts the rest of the world on notice that you have a lien on this collateral, and that if anyone else tries to buy it or take out a lien on it, then they will find that lien of yours on that collateral. The other big part of perfection comes into play in a Chapter 7 bankruptcy. If the borrower goes into a Chapter 7 bankruptcy, the Chapter 7 trustee can avoid an unperfected lien. And in Arkansas, at least, trustees love to find an unperfected lien on a mobile home, because then they can go sell that mobile home and use the proceeds from that sale for the benefit of the unsecured creditors. That's also how a Chapter 7 trustee makes money, is they get a percentage of that. So Chapter 7 trustees love to find those unperfected liens on mobile homes. So, and it turns out the court in Renault told us exactly how you have to perfect your lien. You have to get it noted on the certificate of title, and you have to retain possession of that certificate of title. Excuse me. And they said that's the only way to do it. The only way to do it is it's a car, basically. A mobile home is a car. And you have to get that certificate of title with your lien noted on it. The mortgage does you no good, no matter how well the home is attached to the real estate, whether it has a deck or piers or tie downs, none of that matters. Once it's a mobile home, it's always a mobile home. So that created some problems in Arkansas for a couple of different reasons. Mortgage lenders and servicers were not used to dealing with certificates of title, like I mentioned. And the second problem was, again, a bankruptcy issue. Comes into play in a Chapter 13 bankruptcy, where a debtor, a borrower, has the option of doing a cram down. And that's when the borrower can choose on personal property, like a car or a manufactured home that has not been, let's just say on a manufactured home or a car, they can cram you down and pay only the value. Instead of paying the full amount of debt, they only pay the value. And obviously that's a problem with a car or a manufactured home, because they can depreciate rapidly and the value can be much less than the actual amount of the debt. So that's a big benefit to borrowers in the Chapter 13, and it's a real problem for lenders and servicers. So the Arkansas legislature decided they needed to change the law, and about this time, legislatures all over the country were doing the same thing. And they created a path to make this manufactured home that's treated just like a car, created a path to make it part of the real estate. And the way they did that was to have a statute under which you can surrender the title or cancel the title to that home, and then affix the home to the real estate, and then it's real estate. For what was a car, essentially, now becomes part of the dirt, just like any other brick and mortar or stick built home on that dirt. So the way to do that is, first, you have to affix it to the real estate. And I'll read you from the regulation what that means. It says it shall mean the manufactured home must be attached to a permanent foundation system in accordance with the manufacturer's requirements for anchoring, support, and maintenance, and appropriate for the soil conditions for which the site that meets state codes. Those requirements are found in Arc Code annotated 27-14-1603. And again, once you have it affixed to the real estate, you can apply that statute. You can surrender either the MSO or the certificate of title with all liens released. You surrender that to the state of Arkansas along with an application for cancellation. And there are numerous requirements for what that application should contain or must contain, and the state has a form for that. But two of the things that are important, you have to have the legal description ready to go, the legal description of the property, and the owner of the real estate and the owner of the home have to be the same person. So you can run into some problems there if you've got somebody wanting to put the manufactured home on their mom's property or something of that nature. Surrendering the title is not going to work in that situation. And then the third requirement, in addition to surrendering the title and the application, is recording an affixation affidavit that is recorded along with the mortgage. And again, there's some statutory requirements, a laundry list of statutory requirements that we can always help you draft that here at Padgett. It's something we've drafted for lots of our clients. And you attach that to the back of the mortgage and record it. And then you get back from the state of Arkansas a document that says the title has been canceled. And at that point, poof, it's real estate. It's no longer a car. And when you end up in a Chapter 13 bankruptcy, you don't have to worry about a cram down anymore. So, and there are obviously other benefits. You don't have to mess with keeping up with a certificate of title in a safe somewhere, finding that to go to court. It's part of the real estate, and it is now covered by your mortgage, just like it were a brick and mortar house on the property. If you don't have the title or the certificate of origin, There are a couple of routes you can take, and this is where we can really help you. This happens fairly frequently. You can go to the court and get the court to enter an order ordering the state to issue a certificate of title, so that then you can take that certificate of title, go back to the same office, and have it canceled, just through the process that we just talked about. Or you can go straight to the state and get a bonded title, and which requires putting up a bond for 3 years in an amount that is 1.5 times the value of the home. That's not necessarily an attractive option because of the bonding requirements. Well, I think that kind of covers that process, and Josh will hit on it a little bit more. Let's talk about the Arkansas foreclosure process. We have non-judicial and judicial, and this really applies to both. If the home is still titled as personal property, it's not technically a part of the foreclosure because it's just like a car sitting on the property. But it's in Arkansas is subject to self-help repossession post-foreclosure. So you can foreclose on the dirt on the property. Then if the home is vacant, you can self-help repo that home, take possession of that home, lock it up, so to speak. We include some replevin language in our judicial complaints so that when the foreclosure is over, we can go to the court and ask them to essentially complete a replevin at the same time. In actuality, we've never really had any problems in the situation where we foreclosed on real estate that had a titled manufactured home sitting on it. The court kind of looks at it all together once it gets post foreclosure, and an eviction order that you get post foreclosure will also, and if not technically, in reality, it will be applied to that home, so that once you get the writ of possession, the sheriff will assist you in taking possession of the entire property, including the manufactured home. There's a possibility that you could end up having to come back and do a replevin action to get possession of the home, but I don't think that's very likely. If the title is canceled, you don't have to worry about any of that. It's part of the real estate, just like a stick-built house, so you don't even need to describe it separately in your foreclosure action. It's just part of the real estate. You may want to, for clarity's sake, for when you're advertising the sale, to let people know that there's a home there, but it's not necessary. Once you get to the REO stage of the process, if the title has been canceled, it's part of the real estate, and you sell that real estate, including the home, with a deed, just like you would any other piece of real estate. If you still have a certificate of title to the home, you would have to do a deed as to the home, and then a bill of sale as to a deed as to the real estate, and then a bill of sale as to the home, and then follow the process with the state to get the home retitled in the buyer's name. And that pretty much sums up Arkansas. If you have any questions, feel free to submit them, and we'll take a look at those, and I'll turn it back over to Josh.
Thanks, Mitch. Two things definitely stood out for me in your presentation on Arkansas, and it's the advantages of the deed title in both the bankruptcy arena, and then obviously once you get to REO. So definitely some good food for thought there. And the state of Tennessee is very similar to Arkansas. Definitely the theory is the same. In the state of Tennessee, there is a statute which basically says that the manufacturer of a mobile home is subject to the motor vehicle laws. It needs to be titled and is subject to the motor vehicle laws until it's affixed. And there is a D-title surrender process in the state of Tennessee, similar to Arkansas, and it's in the materials here as far as where it's codified. Where I'd like to start, however, is the actual referral process to us and how we are going to go about dealing with this manufactured mobile home once we have foreclosed. And in the state of Tennessee, 99 out of 100 times, the mobile home curative is performed post foreclosure. The goal of the curative post foreclosure is to obtain certificates of title in the foreclosing investor's name, so that we can surrender those and detitle that and convert the home legally to real estate. In the state of Tennessee, one of the biggest hurdles that we have that we see, especially on those quote-unquote mortgage loans I referred to earlier, is just trying to obtain a good VIN number for the home. A lot of times the loan origination appraisal will have either no mobile home information. It could be an old loan. The detitle statute wasn't codified in Tennessee until 2003. It could be a pre-2003 loan. There's just a lot of times no or very little information with respect to the mobile home out there. So that's really half the battle, is just trying to track down a VIN number so we can see what's going on with that title or whether it's been titled. We often will send have our clients send property preservation out to the property to see if they can take a photo of the data sheet. There is a manufacturer's data sheet located inside of the home that has the VIN number, the make, the model, all that good stuff. And we ask them to take a photo of that and provide it to us. That's really the horse's mouth. That's really what we need to get the ball rolling. However, a lot of times disgruntled borrowers or folks over the years will remove those sheets out of the home, and then we don't have access to that. Another option is there is a HUD plate. It's a little metal plate that's on, typically we're dealing with double wides with an A and B side or a left and right side, and there'll be a metal plate affixed to the exterior of the homes that give us the HUD tag numbers. And there is a vendor out there, which a lot of folks I think on the call are familiar with, referred to as IBTS. They are an independent vendor. They are not affiliated with HUD. They're an independent vendor that keeps a database of VIN numbers. And if you provide them with the HUD tag numbers, they can do a reverse search. And we give them the HUD tag numbers. They give us the VIN number. That's one option. Sometimes the VIN number will be listed in the title work. But anyway, the key is trying to get the VIN number to the home. Once you get the VIN number to the home, we will order a DMV search, and that is going to determine the course of our curative. A lot of times in Tennessee, the home is still titled in a prior owner. A lot of times, sometimes the first owner of the property got the titles and threw them in a lockbox, and they've stayed there ever since. And then that person sold it to someone, that person sold it to someone, and eventually a loan's made, and we do a DMV search at foreclosure, and the mobile home is still titled in the name of that original owner. When that happens, and again, the goal here is clearing off the title so that we can get it in the name of the foreclosing investor. So we have to do a skip trace and track down the prior owner, get the prior owner to execute some duplicate mobile home title forms. We have sent letters in the past to these folks. They think it's some sort of a scam, or they sold the property 10 or 15 years ago, and so they're uncooperative. And so that's one of the things here at PLG that we know how to skip trace and know some tricks of the trade of how to locate people and let them know what's going on, explain it to them on the phone so that they don't think it's some sort of a scam. And we also have to get the lien released off the title. So if there is an unreleased lien on the title, we also have to get a lien release. Sometimes the title is still in the name of the foreclosed borrower. If that's the case, that presents its own unique challenge, because a lot of times foreclosed borrowers are not cooperative in signing title documents after foreclosure. We send out letters. We know how to communicate with the folks and explain what's going on. There is an exception that makes things easier, and that is if there was a lien perfected at origination that matches the deed of trust that we foreclosed on, then we can do that repossession that I referred to earlier. But typically in Tennessee, we are dealing with situations where the title comes back from the DMV, and we just kind of shrug. It's like, oh goodness, and it's literally somebody in the back chain, and we are having to clear them off and also get a lien release. Once we accomplish that goal non-judicially, we then have the foreclosing investor sign some mobile home documents. One of the documents is the key, is affidavit of fixation, similar to what Mitch was talking about in Arkansas. You probably all have heard that terminology. It's an affidavit that basically says that the home is affixed to the dirt. It lists the VIN number. It's said it's being taxed as real estate, and the foreclosing investor will sign that, and they'll mark 8A within that form stating that it has been titled and that we're going to surrender the title. And once that affidavit of fixation has been recorded, all the documents I mentioned earlier, the documents from the prior owner or the borrower and the lien release and the affidavit of fixation, all those documents are bundled together into a deed-title package and submitted to the state of Tennessee for deed-titling.
Hey, Josh.
Yes, sir.
I think it's important to note here, and I failed to do it, was that I think a lot of people think just recording the affixation affidavit is enough, but they have to be sure to go through this next step that you're about to explain as well.
Thank you, Mitch. Great point, and that is so true. I can't tell you how many times I've had clients reject our fee approval post foreclosure, where we send them a mobile home curative fee request, and they go, no, here's the affidavit of fixation. Proceed. You're good to go. And we have to explain to them, as you said, that's just one piece of the curative process. Just because an affidavit of fixation is of record does not mean that that the deed title was followed through. And a lot of times that's what happens at origination, that just kind of to appease the originating lender, they'll record an affidavit of fixation as part of the loan closing. And that's all that's done. And then we do a title search, of course, or pre-foreclosure, and then we review it post-foreclosure. That affidavit pops up, and we don't just stop our analysis there. We have to go through with a DMV search, see if it actually is titled. Now, there are certain circumstances in Tennessee, and we deal with this a whole lot, and that is we submit a DMV search, and it comes back never been titled. This is a situation that is extremely problematic because if you do not give the state of Tennessee, the DMV, the exact VIN number that was titled with their office, the way their computer system works, it just will not find it. So over the years, you kind of see so many VIN numbers and see the manufacturers and how these VIN numbers work that you can probably say to the DMV, hey, take the A off or take the B off or what have you, and sometimes they will find it that way. So that's just kind of one of the things that here at Padgett that we do to through our experience to try to expedite and find the record of that home so we can quickly get started on the curative. Once the deed title has been done, it is, as Mitch said, it's real estate, and subsequent conveyances go by deed. Subsequent encumbrances for loans go by deed of trust, and you don't even have to include the mobile home information in the subsequent deeds. One last item with respect to Tennessee is, and I kind of got off topic, but that is what happens if it comes back and they cannot find the home. And that is after you have tried every VIN variation, you've gotten the title work, you've gotten the origination appraisal, you've got an IBTS search, hopefully you got the data sheet. If you've got all that in your file, we call it a due diligence process under the statute, and we feel really, really good that mobile home was never titled with the state of Tennessee. When that happens and we've documented our file, we then at that point go ahead and tell the lender, okay, by executing 8C on the affidavit of fixation, which says after diligent search and inquiry, we cannot locate a record of this mobile home ever been titled. You can have the foreclosing investor execute that. We can record it and submit it for detitling, and the state of Tennessee, thank goodness, will detitle it. That is a change in the law. That didn't used to be the case. It used to be you would have to go file a judicial action, but that is not the case anymore. Under the new amended statute, if you've done that due diligence process and sworn under oath, the foreclosing investor states that there's no record of the title, then we can surrender it that way. So that portion of the process, curative process, is quick, but the due diligence portion and trying to assemble all those documents and send somebody out to the property, that's the time-consuming portion. The last thing I wanted to mention about Tennessee is that deed title letter, once you get it, it's not recorded. So again, that's just part of the process where we are, getting a DMV search to see if by some miracle at origination, the mobile home was detitled then. I'd like to now move into the state of Georgia. And Georgia is very, very similar in theory to Tennessee in terms of what we're trying to accomplish. The mobile home curative is done post-foreclosure in Georgia, just like in Tennessee. There is a statute in Georgia, backing up a second, there is a statute in Georgia that says that the mobile home shall be titled as personal property until it is converted to real property. and there's also a codified deed title statute that's also in the materials. But skipping to the process, we get a referral post foreclosure. We're doing the same thing. We're trying to make sure we have a good VIN number for the home. That's important. We are also obtaining a DMV search, which often takes quite a bit of time with the state of Georgia. They are very slow to process your DMV search request. While you're waiting on the DMV search to be processed, you can go ahead and move on to something that I know a lot of you have heard about, and that is this infamous T22B form, which is very unique to the state of Georgia. This is a form that must be completed by a law enforcement officer. This is the only state, Georgia, that I'm aware of, at least in the practice states we're in, that has this requirement. And that is a representative of the foreclosing investor must send a rep out to the property to meet a law enforcement officer to fill out this T22B form. The officer must put that he saw the VIN number, identifying information on the home, and he completes the form. And this is a necessary form to complete the deed title process in the state of Georgia. Well, guess what? When that data sheet's removed from the home and the law enforcement officer cannot verify the VIN number, we have a problem. I'm not going to get in that today because there's a lot of moving parts. If you have any questions about that, feel free to reach out to us. But there are procedures in place and options to deal with that when the officer cannot properly complete the T22B form. But assuming he does, you're also in this process trying to get a lien release. You're going to need a DMV search to find out if there is a lien on the title. But again, moving through this deed title process, we have gotten our DMV search. We have gotten the sheriff to go out and complete a T22B. We've obtained a lien release. Here is a definite unique difference between Georgia and Tennessee, and that is we're not trying to track down prior owners and borrowers in the state of Georgia. It is custom to obtain surety title bonds. Mitch touched on that as a possibility in Arkansas. It is almost commonplace in the state of Georgia to do this. Most default firms have relationships with insurance companies, just go-to companies that they know they can get this stuff done. And basically, you are having the insurance company that's licensed to issue surety insurance in Georgia. You are submitting the DMV search to them. They will do evaluation of the home. They look through Georgia records. They also have independent means of establishing value to the manufactured homes. And they will process these bonds for you, create these bonds for you, and the value of the bond is 2 times the retail value of the home. That's by statute in Georgia. But once you get these title bonds, which is kind of a band-aid, but they work, you then take those surety bonds, you take some other title applications that you've acquired from the foreclosing investor, and then you need one more item in Georgia. So unlike the affidavit fixation in the state of Tennessee or Arkansas, in Georgia we have this document called a T234 Certificate of Permanent Location. But it's basically the same thing as an affidavit fixation. It's signed by the foreclosing investor stating that the mobile home's been permanently affixed to the dirt, and that document is recorded. Once you've recorded that, you are now ready to submit all the items that I've talked about here to the state of Georgia, and they will cancel, typically it's called cancel in Georgia, the titles to the mobile home. And then once that happens, the home becomes real estate, just like any other stick-built home, and transfers are via deed and security deed for encumbrances. What happens when the mobile home was never titled in the state of Georgia? You can still do bonds for that process. It is a little bit more complicated than when it is titled, so we want to be mindful of that. And then there is one exception to having to go through the deed title process in Georgia, and that exception is what's called a T234A form. So if we do a title search and we see a recorded T234A Certificate of Permanent Location, what we're looking for is we're looking to make sure that the MSOs, those Manufacturer Statement or Certificate of Origin, we're looking to make sure those were attached to the T234 and recorded. And this applies to mobile homes that were manufactured after July 1st, 2006. So this became a law a few years ago in Georgia. The legislator said, okay, if the home was first sold after July 1st, 2006, you can take the MSOs, attach them to this T234A, record and surrender that. And when that's done and that pops up in our title search, we know that we don't have to do any further curative. That takes us through the state of Georgia. Let's talk about Florida to wrap up the discussion today, and then we will have Q&A. Florida also has a deed title statute. Florida also says that the mobile home is subject to the vehicle laws of the state of Florida, and it's to be titled as a motor vehicle until it is converted to real estate. The process is a little bit different, though, and unique in Florida because we are going to actually do some work at time of foreclosure. So Florida is a judicial foreclosure state, and so we, unlike Tennessee and Georgia, maybe Arkansas to an extent, we are actually looking at the mobile home and dissecting it a little bit at time of foreclosure. We're looking for two things. We can run an online search to see if there is an unreleased lien on the title to the mobile home. If that is the case, we will include that lien holder in our judicial foreclosure complaint. And that way, we go ahead and get rid of them that way and don't have to do that post-sale. One other item that's unique to Florida is we are looking at the mortgage to make sure that the description of the mobile home is proper, accurate, and complete in the mortgage. A lot of times what happens is at time of loan origination, at least on a lot of referrals we get, is it's a new mobile home, and at time of loan application, they don't know which mobile home they're going to buy. They're just they just know it's going to be a Fleetwood, and so a lot of times what gets carried into the description of the mortgage is the mortgage description will say there's a 2000 Fleetwood attached here to VIN number TBD. I can't tell you how many times we see this, and so when that happens, we want to add a reformation count to our judicial foreclosure complaint, whereby we're asking the court to reform the mortgage to include the complete correct description of the mobile home. And that's important so that when we come out of foreclosure and move into post-foreclosure curative, that's all been handled in that foreclosure process. Now, a lot of times in Florida, we do see that hybrid situation where the mobile home is going to remain titled under the certificate of title. And also, it's going to be the land's going to be transferred via deed. That hybrid situation, it is permissible, and we see that quite a bit. But of course, we do need to get those titles into the foreclosing investor's name. So we've got to do that post foreclosure. So what happens is the foreclosure deed and some mobile home title documents are submitted to the state, and the state will actually transfer the titles into the foreclosing investor's name. And at that point, either you could shift to REO, and the title can be delivered to the new REO buyer, and the land can be conveyed via deed. Or if deed title is required, which it is often, then as I mentioned earlier, Florida does have a deed title statute like the other states. And what you are required to do is get those titles in the foreclosing investor's name. And once you get your hands on those original titles, you have the investor sign what's called an affidavit of retirement. And by statute, you have to attach those original titles to the affidavit of retirement and record those. And then you have the foreclosing investor sign some other retirement type documents, and then you surrender those original titles and the affidavit and those other retirement documents to the state, and the state will de-title the manufactured home. And then just like the other states, it now becomes real estate, just like any other stick-built house, and deed-conveyance and lien perfection is via mortgage. And I think that takes us through Florida. And now I think I'll turn it back over to Mitch so that he can start us up on a Q&A session.
Thank you, Josh. As a reminder, attendees can now pose their questions. And we've already got a few, it looks like. Okay, this one looks like it's for Tennessee, Josh. In the state of Tennessee, does a deed of trust encumber a manufactured or mobile home which is permanently affixed to the underlying land if the deed of trust fails to include a description of the home?
And that's a great question. We are typically not concerned in Tennessee with a description of the mobile home being included in the deed of trust. So that is not a deal breaker per se. I know there's some other states out there that have statutes and case law that says if you do not include a description of the mobile home in the security instrument, then you're out. You don't have a lien on the mobile home. That's not the case in Tennessee. The key is going to be checking to make sure or determine, I should say, whether the mobile home was actually detitled prior to the execution of that deed of trust. But if it's detitled, then of course as we've talked about, you don't have to include a description of the mobile home in the deed of trust. But if it is not been detitled and there is a mobile home title floating around out there, the failure to include a description of that home in the deed of trust does not hurt us for foreclosure purposes. We go ahead and proceed with foreclosure, which, as you said in Arkansas, is kind of just a foreclosure of the land. And then, of course, we're going to need to deal with the certificate of title and perform that mobile home curative post-foreclosure.
I would give the same answer for Arkansas, Josh. Let's see. Here's our next question. Can you sell the land and the home separately after foreclosure if the home has been affixed? In other words, can you remove the home from the land if the home is a problem? For Arkansas, the answer is yes. You can, after foreclosure, even if the title has been canceled, you can sever the land from the home and get a new title issued. So you can do this whole process in reverse. The lender or the owner can do it. Again, with the state, you submit an application. This time, instead of an affidavit of fixation, you submit an affidavit of severance. You have to get an attorney or a title insurance agent to certify that the home is free and clear of liens. Then you could get a new title issued to that home and sell it separately from the land. If you were an REO and you thought the land was going to be more valuable without the home on it, for some reason, you could do that.
And that is available also, Mitch, in the other states we practice in. I've always scratched my head at that one. All you hear is the words permanent, permanently affixed and permanent, and there's stuff recorded, and it's now real estate. But yes, in those other states, there statutorily, you can, believe it or not, unpermanently affix and undetitle a home. We've seen some crazy situations over the years, and we could tell war stories for hours about these things, but we've had situations where at some point the manufactured home is removed from the property. I had a person tell me one time when we sent property preservation out to the property to retrieve the VIN numbers off the data sheet inside the home, we got a response that said, well, the home's not there anymore. There's just a nice slab. And the neighbor ran into the property preservation person and told him, well, yeah, the borrower was out here the other day and had for sale signs up. And I came home from work the next day and the home was gone. And so we've seen that. It as you can imagine, creates some very interesting facts and difficult situations to try to see how we can go about chasing down that home. But believe it or not, these homes, even after they're permanently affixed, they can be removed. I've been told it's several thousands of dollars to do it. And I know there's some environmental and safety concerns about, removing a home that's been affixed to utilities, but it's quite an undertaking, but it is available. So this is quite an interesting topic. It's one we deal with every day, and I will tell you this: each and every one of these mobile home files that we get, it's its own animal, and it presents its own issues. I see some other questions here.
Yeah, I was just going to say, Josh, they all have different fact patterns. It's amazing how many issues come up. Let's see, one more question. So if we have foreclosed on the land and try to facilitate an affidavit of affixation, how would that work, as the land and the manufactured home would not be the same owner? So if they're not the same owner in Arkansas, you have to leave it separately titled. You can't affix it to the land. So if the land is owned by one person and the home by another person, you would just have to leave that mobile home separately titled. Is that the same for Tennessee, Josh?
Yeah, and I think looking at the question, this does happen. It's the classic fact pattern in Tennessee. Let me just make sure I'm understanding the question. So we have foreclosed on the land and try to facilitate an affidavit of annexation. How would that work? Well, again, it's a hybrid situation. You're having to cure the mobile home first. You are having to get the prior owner off of the title, track them down in Tennessee, a bond in Georgia, judicial process in Florida. You have to get the title out of that prior owner or foreclosed borrower's name and into the foreclosing lender first. And once you've done that, then you can execute and record the affidavit of fixation. Because as we've stated, all of these statutes require the ownership of the land and the mobile home to be the same. And so, it's very interesting. We're foreclosing and everything looks good. And then we get out of foreclosure, we do a DMV search, and the mobile home's in, 4 owners in the back chain. I would submit from an intent standpoint that we've got an argument legally in court that we're entitled to that mobile home. And when we write these letters and talk to these prior owners, if they even try to make some sort of an argument that they still own the home, we've definitely got some legal arguments in place. And I've only had one person over the years demand some sort of compensation for signing those titles over. Typically, they do it once they understand what's going on. So I hope we answered that question. If we did not answer that, please send us an email for more clarification. But if the ownership of the home and the land are not the same, which they are often not, we've got to get those merged together.
Here's
Mitch,
another
I see another question.
Yeah, so here's a good practical question. Is there anywhere physically on the manufactured home where the VIN number is like on the frame? So where do you find the VIN number? In my experience, it's somewhere inside the home. Josh was talking about the HUD number, which is a different deal earlier. But the VIN number is going to be somewhere inside the home, like under the sink on a little plaque or next to the hot water heater or in a kitchen cabinet. I believe that's right. Is that your experience, Josh?
That's correct, Mitch. It's what we call in the industry a data sheet, and it's in one of those places. Typically, a lot of times in the cabinet where the hot water heater is. It's sometimes in a cabinet in the kitchen. I've had agents and property preservation search properties high and low and not find them. I will tell you there is one last ditch chance at the property, and that is there is an I-beam, a beam across underneath and across, I believe, near the front of the home, where the VIN number is. I'm not making this up, by the way. It is engraved into the beam. And I've only a couple times had to go this far when we've just completely exhausted all of our resources, but I've had to have somebody crawl up underneath the home, get in there, crawl and try to find it. If you Google that on the internet, there is a picture on a site of what an engraved VIN number looks like in an I-beam. But that's an extreme situation, and typically you will find that data sheet, hopefully, if it hasn't been removed, in one of those locations you referred to, Mitch, in a closet and a cabinet. And then also there are those HUD tags, HUD plates affixed to the exterior, although I've had those HUD plates removed over the years as well. I see another question here. The question is, do we have to re-record a deed of trust that is missing the mobile home info if title was eliminated after closing? No, I don't think. I think the answer to that is no. You wouldn't have to do any re-recording of that. Is missing the mobile home that was eliminated. If it's not a state-specific question, if it was Tennessee, again, we're just really not concerned about the deed of trust failing to include a description of the mobile home. There's no statute that says that's required. There's no case law that says that's required. If it's been detitled, you certainly don't have to include it. If it has not been detitled, I think that the inclusion of that information in the deed of trust is only going to help you if you had to litigate that as from an intent standpoint. So if we had a very litigious borrower after foreclosure that would not sign the titles over, we would have to potentially file a quiet title action, and at that point, we're going to argue intent. And I think it really helps us in a judicial curative setting to say, Your Honor, this borrower clearly intended to encumber the manufactured home with this deed of trust. There's a description of it in there. It helps to have a mobile home writer. So if you identify the fact after closing that the deed of trust, that the mobile home information was excluded, I think it wouldn't hurt I think it definitely would not hurt to go ahead and re-record it just to have it in there. You cannot, you're not causing any issues by inclusion of that information in there. You can only help yourself.
Thanks, Josh. I'm told that we're out of time, so I know there are a lot of questions here that we didn't get to. We will have those, and we will answer those and get those answers back to you as quickly as we can this week before Friday. So thanks again, Josh, and thank you to everyone, all of our guests that joined us. This has been a Padgett Law Group webinar. If you're interested in any of the educational resources offered by Padgett Law Group, you can reach out to us at the email address of marketing@padgettlaw.net. We offer trainings that cover national issues as well as state-specific issues affecting your servicing operations in our 4-state footprint of Florida, Georgia, Tennessee, and Arkansas. Learn more at PadgettLawGroup.com. And again, thank you very much for joining us today. This concludes our webinar presentation. You can reach me at mberry@padgettlaw.net and Josh at jhopkins@padgettlaw.net. Thank you.
Thanks, everyone.